Hello everyone, my name is Jin. I'm a licensed Chinese lawyer practicing in Shanghai as a litigator and a counsel. So recently I've been asked by my clients to share some information and experience I've got from serving international clients for the past few years. So I've decided to produce this series of video called Talking to My Lawyer in Shanghai to discuss about those mostly asked questions recently. Okay, so for this video, we're still sticking to the topic called the most asked questions about labor contract. Okay, so we have talked about some of them last time, then we'll talk a bit more this time. Okay, so I have more questions waiting there. My contract has expired, but I have kept working all the same. Is this considered working without a contract, or do contracts automatically renew? Good question. Okay, as I said in the last video, that we suggest everyone to, especially for a foreign employee, to have a written contract with your with your employer. So, but what if you already work for them for a while, but you still don't have a labor contract? Okay, so that would depend on who is the party refusing to produce a labor contract. Okay, if it is an employer who is unwilling to sign the labor contract with you, then the employer shall pay the employee twice the labor remuneration starting from the second month of the labor relationship, meaning, yes, they need to pay you double salary from the day that you started to work for them without a written contract. And that is actually stated by the law. Even you are a foreign employee, that provision will be applied when there's a dispute. Okay? And also, it shall be deemed that both parties have entered into an open-ended labor contract that is with no termination date, or we call a fixed term, the day when the labor relationship hits 1 full year without a proper labor contract signed. In short, that means actually you have an endless term labor contract with your employer from the first day after 4 year working without a labor contract. That's a big hit. The next question is, I've been asked to do a probation period. What does the law say about this? All right, probation is very different here in China. The periods are common, but when undertaking a new job in China, the law does provide something here that people should comply to. Okay, probation periods shall not exceed should not exceed 6 months, no matter what kind of labor contract that you have with your employer, no matter how long is the term of your labor contract. The total probation period shall not exceed 6 months. That's the longest period that your employer can agree with you. All right. If the term of the labor contract is more than 3 months, but less than 1 year, the probation period should not exceed 1 month. All right. If the term of the labor contract is more than 1 year, but less than 3 years, the probation period should not exceed 2 months. If the term of the labor contract is more than 3 years, or is open-ended, or like with no fixed period of end, then the probation period should not exceed 6 months. Okay, meaning that if it is a over 3 year term working contract, or it is a open-ended labor contract, your employer is allowed to agree for the longest probation period with you, which is 6 months. Okay, but again, as I said, a foreign employee is allowed to agree anything different with your employer to the labor law here in China, except for the 5 points that I mentioned in the last video. And a probation period is actually one thing within those, meaning that if you and your employer agreed upon different or longer probation periods clearly expressed in your contract, then the judges, when solving the dispute, might actually apply those clauses agreed in advance between you and the employer. But for Chinese citizens, 6 months is the longest probation period they are allowed to agree with. Okay. The next question is, my employer wants to pay for a training period for me. What obligations do I have in this case? All right. The law stipulates that employers can agree on a service period with employees, specifically when employers provide employees with some kind of training, especially those like expensive professional trainings, like a business trainings, especially out of the location of the business, and then bear the cost and expenses of the training. That is to say, if they pay to train you, okay, if your employer paid to train you, they are allowed to lock you into a contract wherein you must work for them for an agreed upon period. In short, if your employer has paid a good amount of money as a professional training for you, they are allowed by the law to sign a service agreement with you to lock you for another few years to work for them. Okay, and if you breach such agreement, you are deemed for liability of compensate them with any damages that is previously agreed in your labor contract with them. Okay. Next question. My contract has a non-competition clause. What is this, and what does the law say about this? The law stipulates that employers can agree with employees on restricting employees to work in certain industries or conduct business in certain industries on their own for a maximum of 2 years after they leave their jobs. Okay. However, in this case, after resignation, employees shall be paid a monthly compensation of no less than 30% of the salary, of the original salary they had before their resignation during the restriction time. If the employer decides that it is not necessary for the employee to continue to perform such non-competition obligation, your employee is allowed to stop paying you the compensation anytime within a certain period, and you are as return released from such non-competition restriction. Okay, so here's a situation that usually happened, that when someone enter a job with their employer, in their labor contract, there's usually a clause of non-competition, but signing it doesn't mean that upon your leaving of your job, you will be obliged to fulfill such obligation actually as non-competition to your employer, like to work for competing industries or on a business as your own. It will only happen when your employer in written inform you that they want you to undertake such non-competition clause after you are leaving, and also it will only be valid when they started to pay you the monthly compensation, which should not be less than 30% of your previous salary. Then such obligation will be binding to you. Okay. All right. So I think this is pretty much for today's topic. My name is Jin. me and my small associate teams here are running legal support to cross-border cases, including labor disputes, commercial cases, and criminal defense. And we're very happy to talk with you for more questions. Thank you.